Welcome back to our Legal Snippet Law Simplified series. This is our 13th deep dive.
That's right.
And today we're tackling something really practical. Section 256 of the Criminal Procedure Code, the CrPC.
It's about what happens when the person who filed the case, the complainant, well, doesn't show up.
Or, sadly, if they pass away while the case is ongoing. We want to help you, the listener, understand the nuts and bolts without getting lost in legal jargon.
Yeah, exactly. And we've got some good sources today. SEC Times, Capital Baccarat, Rest the Case, Verdictum Analyzing Supreme Court Views.
And we'll also peek at the new law, the Farathia Nagarik Suraksha Sanhita. See how it handles this.
Our mission really is to unpack Section 256, the framework, how courts see it, and what it means in the real world.
That balance, right, between keeping courts efficient and protecting the accused person's rights.
That's the core tension, so let's get into it.
Okay, Section 256 CrPC. The basics. What does it cover?
Fundamentally, it deals with that situation. A criminal case is filed, summons issued, hearing date set, and the complainant is a no-show.
Or they show up initially, but then miss later dates.
Right. Or the other scenario, the complainant dies during the trial.
So why have this rule? What's the main purpose?
Fairness. Primarily fairness to the accused. You can't have someone facing charges indefinitely just because the person accusing them isn't pursuing the case.
Makes sense. It prevents the process just stalling out unfairly.
Exactly. And it prevents unnecessary delays that just clog up the system and prejudice the accused.
So what power does the court actually have under 256 if the complainant is absent?
Well, the magistrate gets some significant options if the complainant keeps missing hearings and there's no good reason.
Like they just stopped caring or couldn't be bothered?
Sort of, yeah. If there's no valid excuse, the magistrate can dismiss the complaint.
Dismiss it. Okay.
Or, and this is important, they can acquit the accused.
Acquit. So find them not guilty.
For that specific complaint, yes. It's a powerful tool to stop a case from lingering pointlessly.
But it's not automatic, right? You miss
Yes.
one date and boom, case closed.
No, definitely not. The court has to look at why the person wasn't there. Was there a genuine emergency? A valid reason?
Like that Himachal Pradesh case, Padam Singh Saini, where the lawyer was stuck in another court.
Precisely. That was seen as a valid reason and unavoidable circumstance. The court can and often should adjourn the hearing if there's a good cause for the absence. Justice shouldn't be compromised by a knee-jerk dismissal.
Okay, so it's discretionary. The judge weighs things up.
Absolutely. It's about ensuring justice isn't undermined, especially if dismissing the case could actually lead to injustice itself.
So beyond preventing delays and ensuring fairness to the accused, why else is Section 256 seen as important?
Well, it discourages frivolous complaints, for one.
How so?
If someone files a weak case, maybe just to harass someone, and they aren't serious about actually showing up and proving it.
The risk of dismissal might make them think twice.
Exactly. It filters out cases where the complainant isn't genuinely committed, keeps the system from getting bogged down.
Right, efficiency again. But also protecting the accused from being dragged through a case that's essentially abandoned.
That's a huge part of it, protecting their rights. They shouldn't have this cloud hanging over them forever if the complainant isn't participating.
So it allows for a quicker resolution in those specific circumstances.
Yes. It balances that efficiency with justice, gives the court options, proceed, adjourn if there's a good reason, or dismiss acquit if the complainant is simply absent without cause.
This seems particularly relevant for private complaints, like, say, bounced check cases.
Very relevant there. Section 138 cases under the Negotiable Instruments Act often rely heavily on the complainant's presence and testimony. Their absence can be critical.
Okay, let's talk legal implications. If the court does dismiss the case due to non-appearance, what does that mean practically?
Well, the immediate effect is that the legal process for that specific complaint stops. It's off the court's list.
And this can lead to acquittal.
Yes. Dismissal due to the complainant's absence can result in the accused being legally acquitted of the charges in that complaint. They are considered not guilty for that instance.
But you mentioned earlier it's not always a final end.
Correct. Acquittal here relates to the specific complaint that was dismissed. Depending on the nature of the offense and limitation periods, it might be possible to file a fresh complaint later. It's not always double jeopardy protection in the absolute sense.
Interesting nuance. And the judge's role discretion is key here.
Hugely important. The judge isn't just a robot applying a rule. They weigh the reasons for absence. Was it justified? Should they grant another chance? Or is dismissal the right call?
It really safeguards the accused from being stuck in limbo if the complainant just isn't pursuing the case.
Absolutely. And think about it. If a complainant repeatedly fails to show up without good reason, it could even impact their credibility down the line if they try to bring other legal actions.
Good point. Okay, let's break down the conditions within Section 256 itself. What are the must-haves?
The default is the complainant's presence is needed. That's the starting point.
But not always.
Right. The big exception is if the magistrate decides their personal attendance isn't necessary. Maybe they're represented by a lawyer, and for that specific hearing, their physical presence isn't vital.
So the lawyer can sometimes proceed.
Sometimes, yes, if the magistrate allows it based on the circumstances. The judge has that flexibility: adjourn, proceed without personal attendance, or dismiss.
And if it is dismissed due to absence.
Then, as we said, the accused can be acquitted on those charges for that complaint, legally cleared for that instance.
Let's focus on the accused again. How does this ensure fairness for them?
It's fundamental. It protects them from that prolonged uncertainty. Facing charges is stressful, costly.
And if the person accusing you isn't even showing up?
Exactly. It feels inherently unfair. Section 256 prevents them being stuck indefinitely. If the complainant doesn't appear, isn't diligent, the accused gets resolution. Freedom from those charges, freedom from that stress.
It's a safeguard against misuse of the legal process in a way. Filing a case and just letting it hang there.
That's a good way to put it. It prevents that kind of passive aggression through the legal system.
What about genuine reasons for absences? We touched on unavoidable circumstances.
Yes, the law isn't heartless. If something truly serious and unexpected happens, a major illness, a family emergency, a natural disaster preventing attendance,
The court won't just dismiss.
highly unlikely. They'll almost certainly postpone or adjourn the case. The goal isn't to punish misfortune.
And if the reason is valid, but maybe less dramatic, like the lawyer conflict we mentioned?
Again, the court has discretion. If the reason provided is legitimate, maybe documented illness, essential travel that was pre-planned, they can adjourn. It's about reasonableness.
Okay, now the difficult scenario, the complainant dies. What does Section 256 say then?
It gives the court two main paths.
Path 1.
Acquit the accused. This might happen if the complainant's own testimony was absolutely essential and now it's impossible to proceed effectively without them.
And Path 2.
Adjourn the hearing. This gives time for the complainant's legal heirs' family members, usually to potentially step in and continue the prosecution.
Can they always do that?
It depends on the nature of the offense, mainly. Does the cause of action survive the death? For some personal offenses, maybe not. For others, especially those involving property or financial loss, the heirs might be able to continue.
And the state could also step in for serious crimes, presumably.
Yes, for more serious offenses, the prosecution might continue under the state's banner, regardless of the original complainant's fate.
So in practice, where do we see Section 256 used most?
Primarily in summons cases, often involving less serious offenses, things handled by magistrates, private complaints like we mentioned, defamation, minor assaults, check bouncing cases, where the complainant's active participation is often quite central.
And the court's decision process.
They look at the reasons for absence, the stage of the case, the nature of the offense, and decide, adjourn, dismiss, or perhaps proceed, if possible, without the complainant's immediate presence. Balancing act, always.
What about the lawyers? What's their role in all this?
Crucial, for both sides. They ensure the rules are followed. If representing the complainant, they advise on the need to attend, explain the risks of absence, maybe argue for adjournment if needed.
And for the accused?
They'll be vigilant. If the complainant is repeatedly absent without good reason, the defense lawyer will likely push for dismissal or acquittal under Section 256, arguing for their client's right to a speedy trial and resolution. They protect their client's interests within this framework.
Let's look at those cases again. They really show how this works. That Kerala High Court case, James A.C.
Right, 2023. The key takeaway was, dismissal isn't automatic. The court must check for valid reasons first. Don't just clear the case off the docket without inquiry.
And Hemant Kumar from 2018.
Similar theme. Careful consideration needed. Balance timely decisions with giving complainants a fair chance. It's not just about speed.
Sunil Mishra in 2015, missing one hearing isn't fatal.
Generally, no. Especially if dismissal would cause injustice. Look at the pattern, the reasons, the impact.
The Bombay High Court case, Champalal, Kapoor, Jain, that seemed to emphasize the magistrate's power to acquit.
It did. It highlighted the magistrate's wide jurisdiction, especially when the complainant was repeatedly absent without good reason. It framed speedy trial as the accused's fundamental right, justifying acquittal in that context.
And Padam Singh Saini, we already discussed, the lawyer being busy elsewhere was a valid reason. Shows flexibility.
Exactly. It shows the unavoidable circumstance exception in action.
Now, the Supreme Court in Anjit Sarkar, 2025, that added a layer, didn't it, about the purpose of the hearing date.
Yes, that was key. If the date wasn't specifically for the accused's appearance, but for something else, like showing cause or presenting an order,
then the complainant's absence on that specific day doesn't automatically trigger acquittal under 256.
precisely. The stage of proceedings and the hearing's purpose matter. You can't just apply 256 mechanically without looking at the context.
And Associated Cement Co., Ltd., the need for personal attendance.
Right. Is the complainant's physical presence essential for this hearing? If not, their absence shouldn't automatically lead to acquittal. Maybe their lawyer can handle it.
The Kerala High Court also warned against using this power indiscriminately.
Yes. The magistrate needs to genuinely conclude the complainant has lost interest, isn't pursuing the case anymore, before acquitting solely based on absence.
And Calcutta High Court and West Bengal Financial Corporation echoed that acquittal shouldn't just depend on non-appearance if presence isn't necessary.
These cases consistently show the courts trying to apply the rule thoughtfully, not rigidly, balancing efficiency, fairness, and the actual requirements of the case.
Okay, let's tackle some common misconceptions people might have. First one, dismissal under 256 means total, final acquittal. Done deal.
Yeah, that's a big one. Reality check. The acquittal is for that specific complaint. As we said, depending on the law, a fresh complaint might still be possible. It's not necessarily a permanent bar.
Misconception 2. Section 256 is mainly for major serious crimes.
The opposite, really. Reality. It's most often used for less serious offenses, summons cases, private complaints, where the complainant's role is often more central to driving the case forward.
Okay. Third one. Complainant misses a date, case is automatically dismissed. No questions asked.
Nope. Reality. The court can postpone or adjourn, especially if there's a valid reason given for the absence. Discretion is key.
Misconception 4. The complainant's lawyer can always just handle everything if the complainant isn't there.
Not always. Reality. In many situations, especially where testimony or identification is needed, the complainant's personal presence is required. The lawyer can't substitute for that.
And finally, once dismissed under 256, the case can never be reopened, ever.
Again, not necessarily true. Reality. Depending on the offense and legal rules, like limitation periods, filing a new complaint might be an option. Dismissal for non-appearance isn't always the absolute final word.
Those are really helpful clarifications. Now, looking forward, the new Parapya Nagarak Suraksha Sanhita, the BNS, how does it handle this?
There's a corresponding section, Section 279, in the BNS. It covers the same ground, non-appearance, or death of the complainant.
Yeah, significant changes.
One specific point mentioned in our sources is a 30-day waiting period. The magistrate should wait 30 days for the complainant to appear before acquitting, unless they decide an adjournment is appropriate for other reasons.
A defined time frame. That's interesting. Gives a clear window.
It seems so. Provides a bit more structure, perhaps, but the core idea remains.
And the exceptions, like representation by a lawyer or when personal attendance isn't needed.
Those key provisions, those exceptions allowing the case to proceed without the complainant's physical presence in certain circumstances, are also carried over into Section 279 of the BNS.
So the fundamental approach seems consistent.
Yes, the core principles dealing with absence, allowing for heirs to step in after death, balancing efficiency and fairness, these seem to be maintained in the new legislation.
Okay, so wrapping up this deep dive, Section 256 CrPC and now Section 279 BNS, they provide this vital framework.
Absolutely. For handling those tricky situations where the case initiator, the complainant, is absent or passes away.
It's that constant balancing act we keep mentioning.
It really is. Keeping the courts running smoothly, not letting cases just sit there.
While also protecting the accused from being stuck in legal limbo indefinitely if the other side isn't actively participating.
And the courts have significant leeway, significant discretion. As all those cases showed, they're expected to use it wisely.
Considering the reasons for absence, whether presence is really needed at that moment.
Exactly. The key thing for you, the listener, to take away is that the law aims for fairness here. It prevents paralysis due to absence, allows dismissal, but also allows cases to continue if there's a good reason or if the cause of action survives death.
It's a more nuanced picture than just show up or case closed.
Much more nuanced.
Hopefully this look at Section 256 gives you a clearer understanding. What other legal areas are you curious about? What other legal snippets should we tackle? Let us know.
Yeah, keep the questions coming and maybe think about this. Section 256 is just one mechanism the law uses to balance competing rights and interests. Where else in the criminal process do we see similar balancing acts playing out? Something to ponder.